My brother Chuck and I wrote the book, The Farah Farah Rules of Law, Common Mistakes That Can Wreck Your Florida Personal Injury Case. Oftentimes, the individual accident victim that finds himself or herself up against a very powerful and wealthy adversary, i.e. the insurance company. So as staunch supporters of the underdog, we wanted to give the victim the information and the means to level the playing field against these big corporations. So the book, we're hoping, will educate accident victims, make them aware of things that go on early in their case. So when they try to resolve the case with the insurance companies, they are assured of the highest chance of a successful result. The insurance companies have undergone a revolution of sorts during the last 15 years or so. They have adopted a whole new strategy in terms of the way they handle personal injury claims. To understand this transition, it would be helpful to know something about the way insurance companies' business was viewed in America. In the 19th century, insurance as an occupational field was on a par with medicine, law, and religion, professions that call for the highest ethical standards. As recently as the second half of the 20th century, the oath for chartered property and casualty underwriters stated, "I shall strive to ascertain and understand the needs of others and place their interests above my own." Insurance companies were thought to provide a vital public service by their very nature and design. Moreover, it was naturally assumed that they could make legitimate profits that would enable them to remain solvent and still meet the needs of the claimant at the same time. Before the insurance companies became controlled by the accountants and the bean counters, they would almost always do the right thing and pay the fair value of claims. I can remember many times in our office, we would make claims to an insurance company on a regular basis and present our clients' injuries and prove the insurance company's liability. And they would pay the claims without the necessity of filing a lawsuit. It was common for substantial settlements to be dispersed in a relatively short period of time, no matter how large a case it was. If a case deserved a financial recovery, the company would pay it. They were guided by a healthy measure of justice. But now, things have changed. When the accountants and the bean counters were allowed to take over, from that point on, insurance companies began to prioritize their profits over the needs of their customers. As a result, the industry started denying claims as never before. They also began playing the delay game in an attempt to frustrate and wear down injury victims whose cases clearly deserved settlements. Instead of looking out for their policyholders, they believe that it is their obligation to earn a return for their shareholders, and they are increasing profits by their refusal to pay what's due to the injured party. This is done by paying the least amount possible on claims at the expense of the victim. When you think about it, the reason is pretty simple, because those who buy a policy and those who are injured by a policyholder deserve to be compensated. After all, that's why people spend their hard-earned dollars for insurance in the first place. So we wrote this book to give the consumer an inside look at how insurance companies view claims, how they handle claims, and what you can do as a consumer to protect yourself in the event you've been injured as a result of someone else's negligence.